I don't want there to be a stampede in the court, but on behalf of all of you and, of course, my colleagues, we have pleasure in welcoming Mr. Amir Khan in our midst today. He is a special guest of the Supreme Court of India. We are screening Lapata ladies, as you've all noticed today on the websites, for all the members of the registry, our staff and our colleagues. So he's very graciously agreed to be present. So I said, why don't you drop into the court and see the real life court in action? And Kiran should also be here. Ms. Kiran Rao will also be here. Kina Purohit is here. So welcome.
Please, my lords. So
we are 20.
My lords, in view of the shortness of time, item 44 is time limited.
All right. We'll go through it now.
Obliged, my lords.
So item 20, who is appearing? Who is appearing in item 20?
Lords. Yes, Lords, myself, Lords. Lords. Yes, Lords, myself, Lords. Lords, my petition pertains to the right.
Why don't you switch on your
Lords.
video?
Yes, Lords.
All right, tell us what is your grievance?
Lords, my petition pertains to the Right to Information Act, wherein, Lords, I had sought some information pertaining to the Lok Sabha election 2024. Lords, I was denied by the information by the respondent by saying that information sought by you is not available in the commission. It may be available with the chief electoral officers of all the states or UTs. And the matter, since matter is related to more than one public authorities, application cannot be transferred under section 6(3) of the RTI Act 2005, Lords. Lords, there is a judgment by this honorable court.
Wait for a second. You had sought information from the Election Commission of India on the voter turnout. You wanted the booth-wise voter turnout in the 2024 elections. They said we don't have the data. One second. They said we do not have the data. The data is available with the state election authorities. Your contention is therefore they should have transferred your request to the state election authorities. You have filed a petition under Article 32. You can file an appeal against the order of the officer in the RTI. You can file an appeal before the Chief Information Commissioner.
Of course, Lords, since the information pertains to the election and it is of high evidentiary value, Lords. It could be of high evidentiary value for the high courts. And Lords, if I go for all the stage of litigation, it may take too much time, Lords. That's why I'm approaching to the court under Article 32, Lords.
We are not denying you the access to the booth-wise data at all. That's not the purpose. But since you are here, there is an order of the information officer in the Election Commission of India that is amenable to an appeal before the Information Commission. So you can follow your remedies in the Information Act. I think that's a better thing for him to do. Veliko. The order which will be passed on the application filed by the petitioner for disclosure of booth-wise details of data pertaining to voters at the 2024 general elections is amenable to remedies under the Right to Information Act. Full stop. Hence, we are not inclined to entertain a petition directly under Article 32 of the Constitution, but leave it open to the petitioner to pursue the remedy in law. Subject to the above, the petition is disposed of. Item 21. 21 is deleted. Item 22.
Wait, please, my lord, I appear on behalf of the petitioner in this matter. 22. Oh, I'm sorry.
I think 20. Yours must be 23.
23. I'm sorry, my lord.
No,
my apologies.
We disposed of a similar case just the other day.
The amount is different, my lord.
We disposed of the petition in terms of the same order we passed 2 days back.
Yes, my lords. But amount is different, my lord.
What is that specially petition number?
This one, my lord? So earlier one.
The earlier order which we passed was 2 days ago.
SLP number 16510.
We passed the same order. The present special petition will be governed by an order which was passed on
5th of August.
5 August 2024 in SLP civil number
16510.
Petition shall stand accordingly.
Amount is different, my lord. 52,33,000.
Yes, therefore governed by the same order here.
Wait, please, Mr. Honorable Court, I appear on behalf of the petitioner. My Lord, at the outset, I must say that we are not asking for any enhancement of punishment. There's been a conviction. The petitioner before you is a judicial officer. After 27 long years of the case being pending in court, a punishment has been imposed. In her opinion, it's not adequate, but she's not challenging that. What she challenged, my lord, is what in her respectful opinion was contempt of court, in that a mob of lawyers, my lord, approached the bench, preventing the court from actually performing its duty. Now the video is fortunately for us available, my lord. There is a CCTV available, obtained officially by the petitioner, which will show you exactly what happened in the courtroom on that day, such that two judicial officers had to abandon their place of duty and come forward to the protection of the the learned judicial magistrate, who all he was trying to do was obtain a victim impact report. The victim impact report was not ready.
Now, the petitioner before us was the metropolitan magistrate in charge of the court on that day. Who was she? The petitioner before us, who was she at that point?
She is, ultimately, she went on in her career, she became a district judge.
On that day, what was she working as?
She was in office as a judge.
I think she was the right? She was the metropolitan magistrate. You are the metropolitan magistrate on that day.
No. She was a district. Madam, what was your position? Post district judge? At that date, on that date. Very well. My lord, she retired.
Getting my question. On the day when the incident takes place in a court.
She was an additional session judge.
She was an additional session judge.
I believe so. No, she was retired. I'm at the time of the incident.
Once
I got the answer. You were the CMM at the time when the incident takes place.
No. My lord, at the time, 27 years ago, at the time of the incident, she was a practicing lawyer. The incident occurred, my lord, in the premises of the Tisazari, when she was trying to occupy a table and chair in the outside area. The gentleman pulled her hair and assaulted her. After that, she went on to become a judge. So,
right.
Yes. So at the relevant time, she was a practicing lawyer. Then she progressed in her career.
This person was convicted.
He was convicted. Now, on the day in question, hold on, please hold on.
Proceedings before us today arise out of the criminal contempt proceeding,
which she filed under Section 15 of the Contempt of Courts Act, having obtained the sanction of the appropriate authority to initiate contempt proceedings. Therefore, I want to make it clear at the outset, she is today not before you asking for enhancement of punishment. He was given a punishment of 20,000 rupees only by way of fine. Although she considers it inadequate, she's not here before you for enhancement of punishment. She rests content with that declaration that she had been assaulted. Now, what we are concerned with is on the day that the matter was listed for judgment. On that day, the accused, convicted person, entered the courtroom with an entire mob of lawyers, preventing the learned judge from delivering judgment. Now, on that date, the victim impact report was not available to the court, so all the court wanted to do was adjourn the matter. But this mob, led by the gentleman who was the secretary of the association, prevented the judge from performing his duties, such that the headquarters district judge and two other judges had to come into the courtroom and try to pacify the crowd and say, please behave yourself. All this is a matter of record on CCTV, and it is also a matter of record, my lord, in the district court's report. Now, what happened, my lord, what we would have expected the district court to make a reference suo motu for contempt against this gentleman who gathered a crowd and obstructed the course of justice. Since that did not happen, she filed a Section 15 application for permission for contempt against them. not against the learned district judge, but against them. Because even I told him, Lord, after all, the learned district judge came there to pacify the crowd and to ensure that the tension in court is diffused. So the grievance is really against the leader of the bar, my lord, who at that time he was in office, a leader of the bar. He went on to become, of course, the president of the High Court Bar Association also. My lord, this is happening all too often, where a mob is being collected, preventing the court from doing justice. So the contempt is limited to that, my lord. Now I have two requests, my lord. A judicial officer cannot be intimidated.
We find from the record that the High Court has observed that the transcript which was filed by the petitioner did not reflect the utterances.
Yes, now I want to explain that.
Second, the audio in the VC footage was unclear due to the crowd which had assembled, since respondent was a former High Court bar president.
Yes.
And these are the two principal grounds.
I understand. I fully understand what is being said. Now, I said,
the transcript.
I want to tell you two things, my lord.
We have the video transcript.
It's available. I filed it in court. I've provided the pen drive to the registry. I'm requesting this court to have a look. Lord, my request is as follows. Your lordship may yourself have a look at that footage of the day on which the mob collected and intimidated the judge. It's clear. There are 5 judicial officers on the dais trying to pacify the crowd and tell them, please go back, please go back, please leave this courtroom. You'll be able to see that for yourself.
Since the High Court says that they have had the benefit of seeing the footage.
Well, not in the open court, and I'm not aware what they saw and what they didn't say. Secondly, they called for a report from the district judge. That report is available.
Start seeing.
Mr. Attorney, we will issue notice here. Oh, you're sorry. All right. In fact, when you moved from there to this place, I thought you wanted to have a better vantage point to address the
I thought your lordship may get the impression we are representing him. I anyway cannot have appeared against him as a Michelson in other contempt.
Lord, it's a matter of time. Your lordship issues notice. My learned friend will represent it.
No,
All
no,
right.
no.
I don't have a problem.
No way.
Your lordship.
He has enough.
Yes, my lord. But two more requests, my lord. Number one, there's a report of the district judge who went there to pacify the crowd. It's on the record of the High Court. Your lordship may kindly ask for that record. It's under sealed cover. It's available, my lord, for your lordships to see. And secondly, the video footage has been provided by me.
Miss Indira, we've heard Miss Indira Jaising appearing on behalf of the Learned Senior Counsel, appearing on behalf of the petitioner. Issue notice. Miss Jaising submits that a report which was filed before the High Court by the then district judge is in the custody of the High Court in sealed cover. But the Registrar General of the High Court is requested to transmit the sealed cover containing the report of the district judge to this court. We make it returnable in 3 weeks, so they have time to.
And that I have provided the pen drive, which has been obtained through official sources.
Right.
I made an application. They provided it to me. It's available to the court to have a look at. I would request, of course, to have a look at it once they respond. Deeply obliged.
Yes, Lord, I am appearing in the matter.
Mr. This is not a case for stultifying the investigation at this stage.
Well, I'll tell your lordship something problematic. Somebody who has nothing to do with our website, nothing, does not use it, does not know anything about it, comes and registers a complaint and proceeds in a matter of law. What are these? And I'll tell your lordship, you're not covered under the relevant statute. This is online gaming. That issue regarding poker not is already a matter which has been said.
The allegation is that you are using, that your website uses bots, and therefore you are the allegation
True.
You know, that those bots are used on the website to doctor the online gaming platform.
No, I'll tell your lordship, I can understand if not, it's a simple thing. On any website, on any app, I have to be a user to be able to say this. Here is a person who admits that he's not a user, he's never used the app. Now, how can you assume it? And we put a certificate, we put certificates to say 3 certificates that we have never used bots. But please see this for a moment. Your lordship, see the complaint. And your lordship judgment plot is very clear. Please see this for a moment. He has no connection. He is not a user. Oh, I'm really sorry, Lord.
But your lordship judgment is there, where your lordships have held that there must be a deceit and to another.
But Mr. Natkani, this is a case where a member of the public says that, you know, there is some manipulation of an online gaming platform.
Yes.
That's all.
Right. Now, that initiates the investigation. The person who initiates the investigation may not directly be a person who is cheated.
No, Lord, I'm not.
No, your lordship judgment, in fact,
Lord,
It's completely setting the criminal law in motion. So why should we interfere at this stage? Because today, if we interfere, we are interdicting the whole investigation.
No, Lord, can I just tell your lordship simply why? It's a very simple thing. Lord, this is a closed platform which is only usable by persons who register, adults who register and use the platform. Now, you have to have a KYC, Lord. We are intermediaries. We have to register. The entire process under law is to be taken. So there is no question. The KYC norms which have been put in place. Now, KYC norm means there's a policy, there's a rigorous policy as to how it is to be done. We place that policy also. Now, please consider the problem that occurs. In a situation like this, imagine not for a moment, somebody who does not use, let's take the example of Google. Somebody does not use Google at all, does not own a computer, says, I've heard that Google is spouting porn or spouting criminal activity, and therefore you must prosecute them. There has to be some basis. I can understand if a person says this is an instance that I have seen, but it can't be it can't be a theory that I believe it is done. And even in the counter that he files in the High Court, he says, I'm in the process of obtaining material to say how this is.
Mr. Luthra.
Yes.
KYC process you are talking about.
Yes, my lord.
It is for the purpose of enrolling the members.
Very
that
true,
they
Lord.
can play the
Absolutely.
so-called game of skill
Yes, Lord.
online, right?
Absolutely, Lord.
Do you have any other valid permission given by any other authority, a statutory authority, to undertake this?
Yes, Lord. Lord, I'll just take your lordship. Lord, we have GST. We are registered with GST.
You are talking about KYC process,
Yes.
registered email, mobile number, identity.
Lord, shops and establishment.
Bank account verification. This is all for your purpose.
Lord, may I just say this?
8,000 members have got enrolled.
Yes, my lord.
Who has granted you permission to run this show?
Now. I'm really grateful for that, Lord. I'll answer that straight away. Lord, I am not required under law to be registered under the local statute, which is the Go Act. That's number one. So today I'm an online gaming portal. I have to comply with the terms of the intermediaries guidelines under 2021, which are there. Lord, we'll just show that.
It's a registered website.
I'm a registered website, Lord. It's a registered company, is registered under the GST, P2 is registered under the Shops and Establishments Act. So all those registrations regarding the company and establishment are in place. And it's not
some offense of cheating by somebody. Sorry.
I told you to carry intermediary guidelines. Intermediary guidelines नहीं. I've कहा था.
8,000 members have got enrolled. Yes, ma'am. 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 8
Just take them out. Just take them out.
Lord, may I just say this?
Lord,
Not
just
not can it. We'll go ahead. Lord, I ask myself, Lord, it's like this. If I was to play not poker today and it is not prohibited, your lordships have held it to allow me a moment.
You're right. But the point is that if the allegation is that the software
Yes.
is rigged
Yes.
by the use of bots,
Yes. Now,
then whether poker is gambling or otherwise,
My
it
Lord,
needs to have practical
I
relevance.
appreciate. Now, I'm not therefore. Therefore, if your lordship,
Today, all that is being done is to investigate.
My
How
Lord-
can we say that there'll be no
my Lord,
investigation?
may I then place not on record annexure P26 in the additional documents?
Yeah.
I placed this before the police. Please see the certificate of assurance.
But that is exactly what the police will investigate.
My lord, but the question is not today. I must say this. I must put it in a slightly different context. Not every information, and not your lordships know that better than me, is not going to be the basis of assumption of a cognizable offense or assumption of an offense. There has to be an assumption. It's not enough to say that an offense has taken place. Please investigate. After all, not day in, day out reports come, but they are not recorded in your lordships. I held that in multiple decisions. Today, not consider this.
Lord, I appear in the other matter. There are just 2 points. There are just 2 points, 2 legal points. Lord, your lordships have already held that there must be in the criminal complaint to establish cheating, the deception, deceit of another person. Not only that, there is one more thing. Lord, in fact, this judgment, Lord of Swapan Kumar Guhas, my Lord Justice Chandrachud as his lordship then was, that for the commencement of investigation, there must be an offense for the purpose of 157. Please have a look at the FIR. Lord, please have a look at FIR. Read court may be able to do it.
Between 1982, when Swapan Kumar Guha, that is Sanchayita, West Bengal.
Yes.
And now,
Sanchayita's case.
you are now in an environment which is governed by artificial intelligence, ICT technology, ICT, and therefore.
But then inquiry can be held, Lord. Inquiry can be held. Why register an FIR first? Lord, police can inquire into the matter.
Not specified.
My lord, please see the regulations for a moment under 2021.
Thank you.
Lord, may I just.
No, we've heard now. Thank you. Item 25.
Lord, anyway.
Item 25.
Please, your lordship.
Just make please. Observations are there.
We just want to.
Lord, may I just say this? May I just say this?
It's a star-studded court today.
Just one request, not in the last matter. Lord, just one request in the last matter. Lord, we placed on record all these issues. Now, the point is, the court, of course, says these observations are limited to the plea of the FIR we quashed at this stage, not in para 19, but not our fear is.
You have clarified that. Thank you. Yes, Mr. Attorney.
Just want to bring to your lordship's notice that
in the light of both Mr. Luthra and Mr. Nadkarni have seen the vagaries of sitting in the front row.
Since school days, we have been sitting in the front row.
No. You're the one in the front row. I've always been in the back row.
I've always been a backbench.
Mr. Attorney was saying that, the Attorney General was saying that it's a star-studded court today.
I think I have the privilege of saying
I was referring to your lordship.
I just want to inform your lordships after the last hearing.
May it please.
Yes, Mr. Attorney General.
I just want to bring to your lordship's notice after the last hearing, we had 3 more officers who have been promoted as captains. And that means the process of consideration keeps happening on the basis of the factors which have been brought to your lordship's notice.
So are the officers promoted?
There are 3 officers. Mr.
Officers? Are they women officers in the Navy?
Women, my lords. Women.
Women officers. So they have moved from being a colonel to captain's rank. So what I mean to say is, in terms of the process already in motion, these promotions keep happening and they'll continue to happen. And as far as the last hearing, we also brought your lordship's notice that when the writ petition has been heard and certain directions have been given to enlarge the scope of a hearing by way of miscellaneous petitions, I think would be probably little unacceptable. And secondly, we've also shown that these three officers who are before the court have been considered on the 3 lookout years, and they're not made it up on merits. And so how far we can keep extending these considerations, reconsideration, reviews is a question for Lordship's consideration. I thought if anything outstanding is left, let them move the Armed Forces Tribunal so that there is a discussion on merits and facts can be considered and matter can thereafter rest where it ought to rest. Colonel Bala is here.
The Armed Forces Tribunal.
May it please your Lordship, Malad. Now, may I point out, Malad, as to why, appearing for the applicant, Malad, in the first instance, as to why this is a case which merits interference, and why, Malad, the army, Malad, has not complied with your Lordship's binding directions, both in Nitisha and Annie Nagaraj. That's the sum and substance of what I am saying, and therefore the application for directions. The second aspect that I wish to point out.
It's not in the nature of a contempt petition. It's in the nature
No, it's
of
not. But Nitisha itself is a case where your Lordships interfered in an IA because your Lordships felt.
Put the original judgment by interference.
No, with the greatest respect, Malad, I don't propose to do that.
If we have to grant you relief.
Yes.
In this proceeding,
yes.
What is the relief that you seek now?
The relief that I seek is, Malad, what I say is compliance with the judgment in both Annie Nagaraja, and so far as Malad, the ACRs are concerned, and compliance with the judgment in Nitisha, both Malods have been breached, and I have just submitted a short note which I'd like to place. It'll take me 5 minutes to place it for your Lordship's consideration. Now, that note is at Malods page 265 of the PDF page. And I'm grateful, Malods, to the learned attorney, Malods, for having pointed out that in the interregnum, 3 lady officers have been promoted. The question that I ask myself is, why have they promoted? Because they've considered the latest ACRs. And therefore, thereafter, because they've considered the latest ACRs, they've been able to make the grade. Now, kindly see my note at page 265. It's a short, Malods, 2-page note. If I may please place that for your Lordship's consideration. The dispute in the present proceedings. Does your Lordship have it? It's at PDF page 265. It's, I think, in a separate folder.
The additional diary. The last document is PDF page 39 of the additional diary. Additional diary.
Your Lordship has it. I'm great. The dispute in the
Yes.
My Lord has
dispute in the present.
Yeah. The dispute in the present proceedings relates to the promotion of 6 applicants from the post of commander to captain. It is significant to state that the entire exercise conducted by the Navy, not a single lady officer was promoted to the post of captain. The genesis of the grievance raised by the applicant is as follows. The judgment of this court in Union of India versus Annie Nagaraj, why it has been held that all lady officers having been found fit for permanent commission shall be entitled to all consequential benefit of pay, promotions, etc., has not been complied with in letter and spirit. 2. The dictum laid down by this honorable court in Lieutenant Colonel Nitisha versus Union of India, to which flagging the casual markings of ACR's qua lady officers as their entitlement to peace was in doubt. Non-consideration of the latest ACRs and benchmarking with those officers whose ACRs were marked with due diligence as per their eligibility to be considered for PC was never in doubt. 3. The applicant submitted the counter affidavit filed by the Navy establishes the following facts. 1. The applicant number 1 was due for consideration in the year 2016. However, she was considered purportedly for the final look by the promotion board only in the year 2018. 2. The applicant was benchmarked with the merit of the last selected officer, that is at page 238. 3. The approach paper which was disclosed to the applicants would indicate that the actual consideration of officers took place only in the year 2021 for the first time. It is submitted that in view of the aforementioned factual positions, as per the counter affidavit, it is apparent that the Navy has considered the ACRs which were casually marked qua the applicants as at the time their eligibility for grant of PC was in grave doubt.
Your contention that the latest annual confidential reports of these women officers 2018, 19, 20 and 21 have not been considered.
Yes, and they admit that in the counter.
Mr. Attorney General, is it correct that...
No, it's not correct. It's not correct. They have been considered for the years 2018, 19 and 20, that the respective lookout years when there were promotion boards. 2015 to 17, there are no promotion boards at all for both men and women.
Can I show from the counter that this is the admitted position, Manoj, that the latest ACRs have not been considered?
No, I'm talking about the board considering for the...
I'm only, Manoj, on the consideration of
the... Attorney General, did the naval authorities not consider the latest ACRs of these women?
No. We have explained it in a counter affidavit. And then there was a grievance that the latest ACRs has not been considered for the three officers to be promoted.
Let me place the note, Manoj, and then I'll go to the counter.
Right.
Yeah. It is submitted that in view of the aforementioned factual position as per the counter affidavit. Sorry, Manoj.
The officers who have been promoted to the rank of captain, do they belong to your group or they are...
No, they are separate. In fact, I have something to say with regard to that. So far as they are concerned, no, so far...
Can we do this?
Yeah.
Today is a Friday, where we need to get to our board. We need a little time, maybe half an hour, to just look at the matter. Otherwise, we might be rushing your case, which we don't want to do. We just need that little mental leisure to do this matter. Can we take it up on Tuesday instead of day or...
Just this Tuesday, I'm in some personal difficulty. If it can be on Friday, Manoj? Friday week?
It will be a holiday, I think.
Friday is a holiday, it's the 16th.
Monday, Manoj? Monday I can do.
You want it on Monday?
Monday week? Monday week.
20th?
Whatever date is convenient.
Let's keep it on the 21st.
21st.
Because that's Tuesday.
Lodge.
Yes.
Lodge.
Mr. Attorney, we'll take it up on Tuesday.
Fair enough.
They have traveled such a long way. The women
I know
officers got permanent commission in the Navy. We just want to give them a proper hearing, a patient hearing.
Absolutely. I will have no difficulty about it at all. Yes.
And I'm extremely grateful for the indulgence. It's all. He can maintain.
Who's appearing in 26?
Lordship, so I'm present. Something is wrong with my video link, Lordship, so I may not be visible to you.
So, Single, just 1 second. Mr. This relates to the appointment of judges.
Yes.
But we have issued notice and we have requested that, we haven't issued notice, we have requested the assistance of the Attorney General. Because
I have one small request to the court. We already have a couple of matters on this subject. I don't know whether there should be a multiplicity of petitions on this, which will add no value to the assistant to the court.
The only thing is this was our order 18th of August 23.
That's true. I've seen that, but I thought on a subject like this, should there be any number of petitions which needs the attention of the court? One petition is good enough.
Lordship, may I just make a very humble submission, Your Lordship? Am I audible, Lordship?
The matter which is pending, Mr. Attorney General?
Yeah, there's another matter where on Barun Mitra, Advocates Association Bengaluru versus Barun Mitra, which is pending and is being heard by the other bench over a period of time. When I have another one small request to the court on matters like this. Yes, I'm sorry.
With Barun Mitra.
Yes, that's right. It's been heard by, this is called for a long period. But now things are happening. Process is taking its own in good shape. I don't know whether the council should file petitions and seek further indulgence of the court. I have some disquiet about it. I don't know. I would probably express my...
Lordship, may I say something, Lordship?
Mr. Attorney General?
Yes.
Are you next week? Will you be in the court physically?
I'll do that.
I think that's better.
I'll do that. Very well. As your lordship directs. Yes.
We'll keep it now next week Yeah, no tarikh hai na.
Then it has to go on 19th perhaps.
We'll keep it on the, will you be here on the 20th?
Yes, you'll be.
Yes, Your Lordship.
We'll keep it on the 20th.
Judgment.
Lord, this matter, Lord, the review petition is the final stage, Lord, the rejoinder argument. If you Lord should take it up after 3 weeks, Lord, 4 weeks.
The court has been apprised of the fact that the review petition
Is in the rejoinder argument stage.
which is pending before has been substantially heard before Aptel, which in that way the matter from a list on after 3 weeks.
After 4 weeks, Lord, the judgment may take some time. Deeply.
I think 28.
Yes.
I have instructions close to what another approach was Aptel for review of the ordinance. There are certain facts which we need to bring it before. I have instructions to withdraw it.
You're withdrawing. Okay.
Only Lordship may just grant me the liberty to approach the Aptel with a please.
Yes.
With liberty.
Item 29.
Please write. For the respondent, this Lawrence Sarchilizanal appearing in this case for on behalf of the NHI. He was here about some. This is the third round of litigation. I am pointing out.
Tell us, why do you have to have, under what provision of law do you seek impediment in an execution petition?
My Lord, Lawrence Solicitor General is prepared.
6 years, the award is
here.
there for 6 years.
You don't have to advance a case where the judges are with you, right?
I'm sorry. Sorry.
Why? Under what provision of law does National Highways Authority seek impediment in an execution petition? You are party to the proceeding. Our court has restored the award, right? The award has been restored. You challenge the award in a writ petition which was dismissed. You are heard there. Now, in an execution, what is the provision of law under which you seek impediment?
My Lord, I will satisfy with since my Lord, SG is appearing and he has a difficulty with, he was here to argue the matter, my Lord. So some difficulty there, small adjournment, my Lord. Can you tell my Lord, Lordship praying, requesting Lordship on 20th, my Lord? My Lord, my Lord, my Lord has already prepared in this matter as per my Lord's instruction. My Lord, SG will apprise, my Lord. I request only to only sort out then. SG is appearing. Lord, SG is appearing, my Lord.
Monday.
Wednesday. Lordship, ordinance. Wednesday, my Lord.
Monday. I will argue it now.
No, my Lord.
Item 30 minutes. Lordship, in previous matter, 20, Lordship has granted to approach Aptel. Yes.
Wait, please, Manoj.
Shoaib, you are ready with the matter now because since he was appearing in person, we thought we should have some assistance.
That's right. Yes. So, Manoj, the first hurdle that I'm facing today is a 165-day delay.
Okay. So,
Manoj, insofar as the delay is concerned, he has filed certain additional documents, and there are also 2 grounds in the delay condonation application. He says, Manoj, that is, if your lordships may have the delay condonation application.
What is the ground for delay?
The ground is, Manoj, his father had passed away, old ailing father, and there is medical record with respect to that. He had bed sores. He was the one who was looking after him. Then he has certain other medical
merits. What do you have?
On merits. Now, Manoj, on merits, striking case where for 24 years he's been embroiled in proceedings. The arbitration started 24 years back. And Manoj, at the end of it, there are 2 claims which the High Court in a 37 petition identifies and says that you're actually entitled to this, but my hands are tied because the scope of a 37, Manoj, as the High Court rightly said.
The High Court, after holding in his favor on merits, why does the High Court say that its hands are tied?
Manoj, because of the scope of a 37. So that is how, Manoj.
Now, his claim is basically for interest on the entire component of EMD. Even that which is refunded, right?
Correct. That's right.
his claim is that I'm entitled to interest not only on that portion of the AMD which is not refunded,
Right.
but on the entirety of it.
That is right. And
That is that clause 4.5.
your lordship is right. 5.3 at 44. Now,
the High Court holds in his favor that that is the clause.
you have an entitlement to that.
So why does the High Court delegate him to
Well,
other?
because the High Court says that I really cannot modify, and it relies upon the judgments of this honorable court that since the scope is,
Award cannot be modified.
or award cannot be modified. So that's where the restriction comes in. So, my lords, my suggestion in the special circumstances of this matter, and especially, my lords, for 24 years that it's been pending, several other claims have also been allowed, is, my lords, your lordship's exercise of the constitutional power under 142. And my lords,
How much would be that claim in respect of interest?
so
1.5 lakhs.
1.5 lakh rupees is the amount, my lords. It's about a 6,000 rupee refund on sales tax.
He's been fighting for 24 years for 1.5 lakh.
That's right, lords. That's right. Vicinity of that. So, please, my lords.
We'll just close our eyes to the fact that there's a delay of 165 days.
I'm grateful.
We'll issue notice to Steel Authority and we'll try and do
I'll be very grateful. my lords.
some
Yeah,
justice
that's
to your
right.
plan.
Some
No
justice.
point in now asking him to invoke arbitration
Again and restart again. And in similar situations where, my lords, there was a similar situation where the High Courts had directed for a reinitiation of the arbitration on some other severed issues. Your lordships have exercised 142 and actually condoned and said that we'll grant something here. So I have those judgments.
We've heard Mr. Shoaib Alam, learned Amicus Curiae. There's a delay. If there's a delay of 165 days, issue notice on the special petition and on the application for condonation. We'll keep it returnable on a particular day.
I'm very-
Otherwise, you might miss.
And thus the service, my lords, will serve the standing council. Very deeply obliged. Yes. Grateful, my lords.
Item 31 minutes.
Yes.
Whereas in 31, even though the state is not on caveat malice, but we have been served with an advance copy in this matter. I have a request to make on the behalf of the learned SG Mallets. If Mallets may keep it on Monday, you will be able to address Mallets.
Very well, minutes. Most
I'm grateful, Mallets.
I am for the caveat. I'd like to appear for the caveat, I'd like to appear for the petitioner. That's the statement.
Millets, before my friend starts, Millets, this matter has been going, there is 31, rolling for 4 or 5 dates. Would your lordships be able to, Millets, take it up higher?
No, we are taking it out on Monday. We would have taken it up, the SG.
No, your lordships is right. No, I'm only asking in a position where it will be taken up high on the board.
No, we take it up on Monday. Let it be done.
Most grateful.
Now, my lord, this is the state's petition. My lord, I have several objections to the High Court's order, my lord, in a writ petition. This is a matter, my lord, concerning supply of electricity. The High Court could not have entertained, my lord, a 226. The High Court says, my lord, in the order, there is no absolute bar to 226, which, my lord, we all know. But if there is a discipline, my lord, of a special law, then you must maintain that discipline. That's the first thing, my lord, your lordship will find in how the High Court has treated that part of the order.
Yes.
Then I'll come back to the merits, my lord. Your lordship will find, kindly, my lord, first see at page 56. Your lordship will first find at 56. Paragraph 8(7). The Electricity Act is an exhaustive code in all matters concerning electricity supply, generation, etc., etc. The High Court is conscious. Then, my lord, the High Court says that this is not, my lord, an absolute reason, and that, my lord, your lordship will find at page 25 and 26, my lord. There is an arbitration clause also. To that, my lord, the High Court says in para 25.
Initially, the CERC had ruled that all agreements PSAs and PPSs would be overridden by the 2019 regulation.
No, my lord, it's like this.
I am the state.
Right.
They have set up a plant in my state.
Right.
They use my land and my water. From there, they make electricity. So I have an agreement with them that they will not give me 12% power free. It's like a joint venture. Free of cost, 12% for 12 years. And for the remaining 28 years, you give me 18%. That is at a time, my lord, when there is no PPA. I am not concerned with any PPA. I have a JV.
So what is the effect of the 2019 regulation?
And now what happens is, my lord, they rely.
2019 regulations cap it at 13%.
But that is, my lord, between the parties to the PPA.
Yes, that is regarding PPA.
Kindly appreciate, my lord. The PPA is between, my lord, this party and a third party called PTC.
PTC.
In that, my lord, this is mentioned. And my agreement says that irrespective of whatever may happen, this is what you have to give. I can't, my lord, as a state, you enter into a solemn agreement today in 2005. And then say after 20 years, some law has come by which I have a contract with somebody else and that caps it at 12 and therefore you are capped at 12. How can you affect my JV? You go away then.
Those regulations of 2019 have no impact on you?
According to me, no impact. The High Court has wrongly, now what the High Court did. When this 13% cap came, they filed a writ petition.
Correct.
Writ petition is completely not maintainable. You have an arbitration clause. They filed a writ. The High Court says that your agreement, which is much prior to this CRC thing, must stand aligned to what the subsequent document is, and therefore your 18% will be scaled out.
The only thing was that they had moved the CRC
for fixation of tariff.
For fixation of tariff.
That is between them, and their
by its order of 17th of March 22.
Yeah.
CRC says that the free powers to be supplied by respondent number 1 to the state was considered at 13%.
But it can't be to the state because I have a separate agreement of 2006.
No,
how can I be
1999?
Or 99?
But the CRC order specifically contains a stipulation so far as you are concerned?
It does. On that basis, my lord. And
so what is the remedy available against the CRC order?
Now, my lord, there are 2, 3 things. You have a right of appeal. Anybody can do whatever.
So you would have been entitled to file an appeal?
I could have.
Only for 6 months.
But not this. Now see, Lord. This period is 2019 to 2024.
March 20.
It is not for forever. This order has come, my lord, in 22 or 23. They go and find a mandamus, my lord, in the High Court that since this order of CRC has come, you now, by a mandamus, with our agreement, with them and the state of 99. So the High Court says, I will tinker with your agreement because law overrules the contract. This is law, subordinate legislation, and therefore your cap will be the 30.
Got your point. Yes,
now, my lord, therefore, now, my lord, the state is deprived. If you don't want to give and you want to renege, please go away. I can't be JV for 40 years and then will not be stuck by events after 10 years, 20 years to say that you are now there. And how does the High Court entertain at 226? Neither 226 maintainable nor arbitration. And now, plus 5 years is over. 5 years is over.
Correct.
Despite that, for the next 5 years, which will be 24 to 29, they are capping it at 12%.
Yes.
Their obligation is 18.
Yes, even today.
Yes, Mr. Chairman.
Lord, 2 points. Tariff regulations were made in 2019.
Right.
He is a deemed licensee under Section 14, proviso. He is a deemed licensee. Tariff regulations bind all licensees. Tariff regulation of 2019 was not challenged by anyone. Tariff regulations capped it at 13%. Point 1. Point 2. He was a party to the CRC order dated 17/3/22. He did not file an appeal against that order. So both are in my favor. The regulations are in my favor. The regulator's order, adjudication order, is in my favor. He did not challenge the regulation. He did not file an appeal. But ignoring the regulation, ignoring the order, he demanded that I supply 18% free power, failing which he will terminate. Therefore, I went to court. Where do I raise a dispute? The regulator has already
He
decided.
was a party to the CRC order.
He is a party to the CRC order. He didn't file an appeal.
What did CRC direct insofar as he was concerned?
CRC said that the 13% is on the tariff regulation and therefore it binds everybody. You cannot give more than 13% free power, and that alone will be taken into account for calculating the annual revenue.
So right or wrong, he was bound by the order of the CRC.
He was bound. He's a deemed licensee. He's bound.
Carried it in appeal to
He
APL.
could have challenged the regulation. He could have challenged the regulation saying this is interfering with my whatever rights state has. He could have filed an appeal against the regulator's order. Where do I raise a dispute? I can only go to court when he threatens me. When he threatens me
if you
with
don't comply
termination.
with my...
Yeah.
Two more sentences, Manoj. That order which your lordship will get at 6:15 to 6:17.
It's only.
Well, it's my learned friend, not only a party.
That's an extra 315, right?
Yes, 17,322. It starts as 5:38. I'm again sorry, your lordship should be having the PDF. It starts at 5:38. Maybe the PDF is 577. This is very interesting.
Starts at 5.
577.
There they are, Government of Himachal Pradesh, Shimla.
That's right. Now, the relevant portions are two, para 144 and 147, which is at page 615.
Internal page, right?
Yes, Manoj, the normal page, not the PDF page. It should be 654 PDF. Otherwise, 615. Now, your lordship will note one thing. What is CRC, Manoj? CRC comes in only on multi-state. Unemployment is a state. CRC comes in only when there are multi-states. Otherwise, there is no intra-state. There is a regulatory authority. So, he is a state who is a party. He accepts this. He doesn't challenge it. Then, Manoj, when they demand and I go to court, the court does what? The court cites your lordship's PTC judgment in 5 paras. PTC, your lordship, considered the issue in great depth and said in 5 paras quoted in the impugned order that you cannot have the regulations being trumped by any form of circular, contract, otherwise what was happening? Why was Electricity Act created? You were having free electricity supplied here and there.
The finding that you are relying upon?
Yes, 144, which is page 615.
PTC cited in 146.
Yes, see 615. How can he be there and not challenge? He's now doing a collateral challenge. 144. We have examined the matter in terms of the implementation agreement. Does the sentence start with? The para is more reliable. We have examined the matter in terms of the implementation agreement dated 18th of November. The petitioner and the government of Himachal directly. Free power equal to 12% of net generation is to be supplied by the petitioner to the government of HP for the first 12 years from COD for the next 20 years after expiry. PPA, supplementary PPA executed by the respondent defines the term free power, which is the same as the aforesaid provision in the IA. It is therefore evident that the issue of free power is significant and relevant for the 19 to 24 tariff period. Now come to 147, 2 pages later. 146 and 147. PTC is only 1 para here. In the impugned order of the High Court, it's in 5 paras. Quoted. 146. PTC has laid down the principle whether any provision of the agreement falls in the domain of the regulations or subordinate legislation has to be aligned with the regulations. I mean, your lordship is being asked to fault the High Court for following the lordship's judgment. The relevant portion is as follows.
No, read that.
And one must understand why a regulation. Last 5 lines, Manoj, last 5 lines.
Once you have the CRC order,
it doesn't go to appeal.
Possibly, we assume for a moment that it's an erroneous order. It's an order which binds you. You had to challenge the order. You never assailed the order in an appeal.
Kindly come to 617.
617.
We are on 617.
Your Lordship, see 147.
Yeah.
Thus, the provisions of the PPA. My agreement with him is called Implementation Agreement of 99. It's not a PPA.
Yes, sir.
Thus, the provisions of the PPA executed by the petitioner JSW with PTC in respect of free power to the home state is wrong. Free power to the home state comes from an implementation agreement, which your lordship will see now. Just kindly have a look at that.
144 talks of implementation.
It may be a party, but this, with respect, how can this come in my... Sorry.
144 talks of implementation agreement. First line of 144.
Electricity board. We were, but
in terms of the implementation.
Objection I have.
No, 1 minute.
There is an arbitration clause.
Implementation
There
agreement.
is an
is mentioned
arbitration
the first
clause.
line.
How can you file a 226?
Implementation
There
agreement.
is an act here.
144.
Yes.
Suppose, my lord, I would terminate. My lord, the Chief Justice said, you are a party. I will terminate your agreement. Can you file?
Because he is demanding money.
Arbitration, the lordships have said, is by and large an absolute rule of arbitration. Can't do this.
Contrary to the regulation and contrary
You are
to the
dodging your
regulator's order, he makes
the
an
state of
illegal
Himachal
demand
Pradesh.
upon me. The illegal demand can only be challenged under Article 226.
I'm sorry.
The arbitrator is the regulator.
But why can't he go in the appeal to APTEL? Why can't he go and appeal to APTEL?
Suppose, my lord, suppose, my lord, yeah.
Why did not
My
challenge
lord,
the
I can't say, my lord, for some reason they didn't challenge. I didn't challenge. I am bound by it. Therefore, my lord, there will be a mechanism to execute the order. That mechanism will have to be, my lord, in the act. The mechanism will be in arbitration.
Yes.
The mechanism of execution can't be in 226 that I will align. When you align, you have, my lord, a decree, you execute it, you don't find a 226 to execute a decree.
Basically.
Therefore, the first question is, my lord, is the chicken and egg story. First question is, could you have gone to the High Court?
Yes.
In the presence of a self-contained code, number one. And number two,
Arbitration clause.
the arbitration clause. How can it be, my lord?
Well, if a government authority
Says you can align, must align. PTC says.
Cannot be aligned.
No, please allow me 1 minute. If a government authority makes a demand upon me contrary to a statute, should I not go to Article 226?
No, you will go to arbitration.
This is a government authority contrary to a statute.
will render judgment.
It's a huge matter for the state.
Absolutely no state.
But the Lordship will be very clear. Next steps, question, sentence will be give me interim relief.
No.
Your Lordship should not bother at all. I'm objecting. I'm objecting.
But after the order, they are giving you only 12% against 18.
For a long time.
1 second, please. I am saying, give me 18. I am the state. If I lose, we will adjust, my lord, for the next 20 years.
Long time is getting 12.
The state is leading in economic problems, lord. We've had flood festival, we've had. You are a big company. Why should you not give me 18 subject to lordship?
It's a 28-year contract we can make up later if we lose.
If I was to lose, there is 28 years of adjustment.
Explain the mechanism.
Yes.
There's a mechanism to making up.
Please,
We lie in favor of, my lord, a state and its people.
Alternately, if today, the difference between 12 and 18, suppose you requisition 18%, up to 18%, you'll have to pay.
Yes.
Otherwise, you'll have to pay.
No, he doesn't. It's free power, my lord, for him.
This is all problem of free power.
My lord is saying,
He doesn't
if I
pay.
get 12, but I want 18. That's what
It will be adjusted, Malad. It will be adjusted.
No.
But there is one more.
Please see this, my lord. Free power, the total power minus free power is the saleable power. If I give him 18, because the regulator's order says you can only give him 13, my saleable power will be calculated at 87%. The division bench has gone into it, 87%, whereas I'll actually be able to sell only 82%. The 5%, I won't get any money.
Cascading effect on the entire tariff.
The
entire tariff.
Not selling even to. Let's see one more thing.
No, Lord. The order is in my favor.
Yes.
High Court is in my favor.
They have succeeded before. Yes.
This was a period of 2019 to
24, March 24.
The ban is 24. Now there will be a separate ban for 24 to 29.
Right now, my petition agreement comes again.
At the moment, there is no fresh fixation.
Yes.
For 24 to 29.
Correct.
Will be done.
Same principle of CRC.
But continue. There is no fixation today. Then my implementation agreement of 18 must survive.
No, my lord. Until the new regulations are framed.
We will hear it out. Lordship will hear it out.
Since they have succeeded, it would be unfair to now
Lordship, please.
them down. There's a division bench judgment. We'll simply issue notice.
Lordship.
We'll give you 3 weeks time to file a counter.
Lordship,
Hear and dispose it.
I have a very short issue.
Can you file a counter in 2 weeks?
Yes, certainly. Certainly.
End of September, bloody also may give it.
September, we keep it.
Very short.
Certainly.
Grateful.
We oblige.
33. Made peace allowed. Now, this is the matter where Wazir X, which is the largest cryptocurrency exchange in India. Yeah, my lord, I'll explain. No, my lord, give me a moment. A reason why.
have invested in cryptocurrency through WazirX,
My lord.
who has frozen the account on pretext to some hack.
Let me give me
The ordinary criminal.
I don't have. My lord is the only.
Remedies under 32. We are not going to get into.
My lord, give me 2 minutes. Let me explain my case. My lord, there was a hack. 1.6 crore users have been affected. 2,000 have gone. I'll just explain what transpired and what they are doing. Why, my lord?
Judicial remedies under Article 32. You can follow any other remedy.
My lord, that's what. Let me place. There's no other remedy. There's arbitration clause. We have to go to Singapore for arbitration. 1.6 crore users. Let me explain what they are doing and why is the time. Today or tomorrow, my lord would have to interfere, and today is the right time. Let me explain. Give me 2 minutes, my lord. My lord, what happened? There is a hack, and 2,000 crore they have lost. They were trying to transfer from account A to account B, and they ended up transferring to account C. 6 levels of verification. To my mind, something hanky-panky happened. Money must have gone to the director themselves, routed somewhere. Nobody knows what transpired.
Disputed question.
Yes, correct. Now what they are doing is, just 30 seconds. 30 seconds. Last 30 seconds.
34.
Last 30 seconds. What they are doing right now.
34 is called out, sir.
I have filed an IA in this matter seeking intervention in this case. The IA number is 174950.
Who's all right? Who is appearing for the petitioner?
I'm here, Lordship. Lordship, my video is not working. Am I audible?
Who's appearing for the Union of India?
Lordships, I'm appearing on behalf of Learned SG, my lords. We need some time to file counter.
All right, let the Union of India file its counter.
Under the similar matters, your Lordship has listed on the tentative list on 21st. Well, this is it's the age of consent.
What is that? I remember. What is that number?
Well, the number is, I'm sorry, 10036 of 2022. 10036 of 2022.
We have now given you enough time to file a counter. File your counter within 2 weeks.
Your Lordship, I am appearing in this matter on behalf of NCPCR. We have moved an intervention application.
File your counter.
Your Lordship.
35.
Yes, sir.
Who is appearing for the Union of India here? Bati, any counter here by the Union?
Please unmute. Yes, my lords, I'm appearing for the petitioners.
Because the matter is being dealt with comprehensively by the High Court, my lords. We are assisting the High Court.
My lords.
There are lots of constructive and positive changes that have happened.
There is an urgency.
Delhi High Court?
Yes, my lords. And it's now at the verge of, there's an amicus that is appointed, and my lords, the matter is going on. The petitioner is also appearing there. My lords may like to wait.
The High Court.
Please, my lords.
May I submit?
I think he also will make that request, Lord.
Mr. Baines,
yes,
you are appearing in the High Court in that matter?
My lords, I am not appearing in the High Court. My only submission to my lords is that ever since a notice was issued in this matter, this is about the muscular dystrophy disease. Now, almost 250 parents came with their children to the Supreme Court. Notice was issued. Now, what has unfortunately happened, and as an officer of the court, I'm bringing this to my lords' notices. It's been 10 months that notice was issued. 5 of the petitioners are dead. 10 are critical as of I speak. And they are under the protection of the court. Indeed, I was reading my lord's observation in Mumbai Mirror case, where my lord has really described the plight of children in a constitutional democracy. I mean, we are living in a rule of law. How can we have a situation?
Which is the matter pending before the Delhi High Court?
My lords, I am not aware of that. I am not a counsel in that.
Himself has attended those. There's a very constructive.
You are appearing in this matter?
I mean, for the state of Assam, but for Assam, our state situation is a little different.
Right. Now, we want to, Mr. Baines, which is the matter before the Delhi High Court?
My lords, I am not a lawyer in that. I am not aware of that, my lords.
Then let me file a response. I will place all that.
I'll let you file
the Delhi High Court matter is also at the again.
File a short response, at least on the Delhi High Court matter.
Please, my lords. No, I'll also show to your lordships what are the changes that have happened to our policy, how money has been.
On the request of Ms. Teshwaya Baki.
My lords, may I submit one last thing as an urgent measure?
File a counter. I have to do it in the meantime. We'll call for a little counter from the unit.
If I may also. My lords, last interim. Just if I may, Lordship in 35 for Assam seek permission to bring some more facts on the record. My lords, can they please to the state?
This is that Manipur students matter, my lords. After your lordships directed me and Meenakshi ma'am to, my lords, sit and try and resolve the issues, we have been working on those issues, my lords. One issue that remains is they are saying that we want a complete transfer from one university to other. That cannot happen, my lords, because these are affiliated to that, and we will, my lords, whatever short of that.
Can you give us a statement
Lords, may I make a very brief submission? My lords, if my lords will allow me, just a very brief submission.
I was going to request this, my lords, that there are nodal officers appointed by the universities to ameliorate the problems that are happening. If anything remains, either your lordship may consider, let it go to the committee that your lordships have appointed, headed by Justice Geeta Mittal, my lords. They can look at any other issues that are remaining. This is...
That cannot happen, and I'll point it out for a good reason why. My lords, we are today only about 25 of us who are there. The list is before my lords. Now, we may be science or students who have also practical classes. Number one, online is not on. Number two, practicals cannot be conducted because Assam University says we cannot allow you practicals here. Neither does the Northeastern University say. We are 1 year away from the time when we discontinued our studies, over 1 year. We have requested, neither Assam University is coming forward, nor is the Northeastern Hill University coming forward to accommodate us. Please allow us to be taken in any central university that will accept us. And there are about 50 of them across the country.
Yes, Ms.
There is another one aspect that I will need my God's help to resolve. My lords, I am only talking in terms of solving this issue.
I have instruction on each of them, each of the students, what we have helped them out with. Online counseling is on, online classes are on. We are also accommodating them for practicals in these other universities. The problem is they want, my lords, they want the practicals, etc., to happen in Delhi or other areas where they are staying. We have said that they can have, my lords, these practical, they can have guides in the Guwahati, the Assam University and the Northeastern Hill University. These two places, we are arranging all of that. Also, nodal officers are appointed by the universities to sort out any of the problems. They can't be transferred.
My lords,
where are these students presently situated?
my lords, across the country, once they left.
Why don't we give them the benefit of joining some central university close to their place of residence now? They have not left Manipur out of their own volition.
May I inform
They have all moved out because of a very serious situation. Yes, Ms.
May I inform your lordships, various committee reports have been submitted to your lordships where these issues have been addressed. In fact, these very issues have been addressed in 4 committee reports, your lordships, in report number 17, 20, 21 and 22, your lordships. In these cases, your lordships, the committee is looking into all the grievances, and as Ms. Bhati has said, all the persons have been approaching the committee. Online facilities have been provided. NALSA and SALSA is also involved, your lordships. If I may just ask your lordships to look at report number 17, which is dated 12th of December 23.
My lords,
the only, sorry.
Yeah, 25.
20.
You have the information about each of the students?
Yes.
Where they are at present, where are they residing?
Your lordships, whoever have approached the committee, we have their information. If they have not approached,
Allegiance, 25 students.
my lords, just one. I may just say.
One second. 25 students who are pursuing their education at NIT Manipur have been displaced as a result of the situation in that state.
My lords, Manipur University, NIT issue we had resolved.
All right, of Manipur University.
Yes, my lords.
Good stuff. They are presently seeking a transfer to any other central university.
JNU, they have said, and they have said JNU, but JNU is not ready to give them admission, but MU.
Some other central university. Let's not identify them. At this stage, we permit the Learned Council appearing on behalf of the petitioners to submit a common note, a note on behalf of all the 25 students to the committee chaired by Justice Geeta Mittal. Full stop. We request the committee to look into the individual grievances of each of the 25 students and, where possible, to ameliorate their grievances by issuing necessary directions to the nodal officers.
My lords, may I just make one submission here before my lord concludes the order?
Maybe definitely completed within a period of 1 week. In the event that the committee requires any further supportive directions to be issued by this court, that may be indicated in the course of a brief report which may be submitted to the court in the meantime.
My lords, that
Lordships may say
my lords, the only thing that I was submitting is have in a way addressed that, but the point is the direction to shift from Manipur to a central university, that direction only my lords can pass, that perhaps the committee will not be able to do.
So we have said if they require some supportive direction, they may indicate that. We'll pass that final order. Let the committee make the arrangements. In the individual cases, we'll pass a formal order in terms of the report of the committee.
So, my lords, we will supply the entire list. In fact, we can do that today. It's all ready with us.
You can sit down and look at it.
Yes, Aurora can give it to me also. I'll send
Yes,
it
definitely. My colleague is there. She will hand it over to you right away.
With my lord, my item was 36, my lord.
My lords, we're keeping everything else after 2 weeks.
No, my lord, my item was 36. They addressed on 36.1. My item was 36.
Okay.
What is 36?
36, we moved an IA, my lord. I'll tell my
We
lords.
pick up your IA on Monday.
Very well.
Your lordships, just one submission. Your lordships, just one submission. Central matter is done, your lordship. You just need to pass a judicial order. They've already facilitated us.
Found a solution. My colleague is right. We handed over them a proposal. We are, Malad, we will find transfer in these 3 universities. May we hand this over, Malad? Your lordship may record this.
Which CL number is this?
Dental.
Dental, all right. Give it to us because you have to write. Give us.
79424 is the IA number, Malaj.
Your lordship.
There's some problem in finding solution. We have found solution for them, Malad. 16 students want transfer. So, Malad, they can.
Your lordships, out of 16 students, 15 have been accommodated. There is issue with only one first year BDS student, which they have not been able to find a seat. If you can just look into that one first year student.
Landesh has handed over a communication dated 12th July 2024 by the Deputy Secretary of the Dental Council of India. Stop. This communication contains the modalities for processing the transfer of how many?
15 students.
Of 15. 15, right?
16, Malad. 16.
Out of 16, one, it has not been found. They've said that.
We've found
15
solution.
BDS students from Manipur to other institutions.
Yes, ma'am.
Good stop. The communication is taken on the record. Good stop. Ms. Aishwarya Bhati has assured the court that in the event any further difficulties emerge, the Dental Council of India would resolve them at the earliest.
The time-bound manner, if your lordships may please
So this may be done. This may be done preferably within a period of 2 weeks from the date of this order.
oblige your lordship.
All right. Item 37.
Grateful, ma'am.
My lords, I appear for the petitioner, my lords. As per office report, my lords, as per office report, my lords, the service is not complete, my lords.
Service is not complete?
Yes, my lords. With the
All right,
report
then
that
keep it after,
my lords.
keep it after 3 weeks.
The service.
Item 38. Keep it after.
Lordship, I am appealing for the petitioner, Lordship. I think the short note has already been filed in the closed envelope as per the office report, Lordship. But there are two sides, Lordship. For making
this, we'll study Mr. Justice Shai's short note. I have not personally seen.
I have not the copy.
You can take a copy of Justice Shai's.
Highly obliged,
Give a copy of that, and we'll keep this on next Friday. In the meantime, let's study the note.
Rather on non-miscellaneous day, any non-miscellaneous day, Lordship.
7, my lords.
39.
I appear for the opposite party. Respondent number 5, my lords. We have filed a counter. It has not come on board today. Your lordship may post it to some other day after a week.
Item 39, your lordships, a counter has been filed. Probably it's not on record as yet.
We have also not gone the counter here on the record.
We have filed a counter. I appear for the respondent number 5.
Yes.
We have filed a counter yesterday
So Parija, then you circulate the counter to everybody else.
Yes.
I'm grateful. Your Lordship may fix a date.
Your Lordship may give me time for rejoinder. It may come up after 3 weeks.
3 weeks for rejoinder. Take it on Friday.
Friday next.
We'll take it up on Friday.
Friday next.
Grateful.
Friday is a holiday, so we'll take it up on the Monday after that. So we get 10 days.
And the interim order may continue, Your Lordships. Because Your Lordships had passed an interim order up to today. All right.
Lord, I beg to appear in this matter. This is that, Lord, right to education schools from Maharashtra. Lord, may I only point out, there are some other appeals which are also coming. Lord, there are 4 different views taken by the High Court. Lord, the view taken by Allahabad, Lord, is rendered by my Lord the Chief Justice, which is, Lord, a view against me. The view in my favor is Karnataka. Maharashtra has followed Your Lordship. All the appeals, Lord, are in this court, which are in the office now. Lord, it will have to be considered whether Your Lordship's hear it or another.
The other matters?
Yes, sir.
We'll bring all the appeals here and hear them.
So,
but what is wrong with this judgment? Because ultimately, what the rule which was framed by the state government says is that if there is within 1 kilometer an aided or government school, then you did not comply with 12.
What happens, Milord, is like this.
That is directly contrary to 12.
So all the other states, Milord, had similar legislation.
Yes.
In all the other states, so 2 high courts have taken the view in my favor, 2 have taken against me. All 4 matters are here, which are indicated in the office note. So, my Lord, the view of my Lord the Chief Justice in the Allahabad High Court, my Lord, is the view which is against me.
But we will deal with now the Maharashtra matter. We have got the Maharashtra matter here.
So I am only saying, my Lord, that I have to propound the view, my Lord, of the Karnataka High Court.
You show us, you argue the matter on merits, we'll look at the Maharashtra rule.
Yes.
And see what it says.
Yes.
The Maharashtra rule says that you will not be required to comply with the RTE Act.
Yes.
If you have a school within 1 kilometer radius, either an aided or government school.
So, my Lord, is like this. The state's affidavit in the High Court was that we have the primary responsibilities on the state under the Act. Section 6 is primary responsibility of the state. It is not mine. The state is on record to say that we have established so many schools that there are vacancies. People are not coming to our schools. If that be the position.
So, that's the reason why these children from EWS sections must go to good schools. Why should we relegate them to state schools?
Lord, this was the same view was in Allahabad. Allahabad view, Lord, Allahabad position was that once you fill up and you require more, you come to us. That was, Lord, in Allahabad, which is mentioned here.
Ultimately, Mr. Rodgi, the point is this.
Yeah.
Children belonging to the economically weaker section, they must get an opportunity to school in good schools.
But Lord, the obligation is on the...
Merely because there's a government school or a municipal school in Mumbai within a 1 kilometer radius, to say that private schools will be exempted from the Right to Education Act.
It is only because if you are within a cluster, Lord, kindly appreciate the scheme.
I thought it's right.
Lord, the obligation, that is the Lordship's view, Lord, also in Allahabad.
Is that correct? I mean, but we'll look at it here.
No, that's all right. So, I'm saying in a lighter way, I'm not saying it other way.
Only to the extent.
The question is, if the state's obligation is met by the state, and I am not a primary obligation provider, I am entitled to say that within my periphery, you have so many schools, you will go to those schools. And when the state sends...
Ultimately, if we want to give children belonging to the economically weaker sections a real chance at life, they must be given education in good schools. Today, why would a parent want to send their child to, say, a municipal school when they have an access to a good school? Also, I'll tell you another thing, Mr. Rodgi, and this is something which we don't necessarily comprehend. It also fosters good education for students belonging to resourced families. Because when they interact with children from marginalized backgrounds, when children interact with students belonging to the economically weaker section, their quality of education is as much improved by you understand what India truly is. Otherwise, children coming from very good families, going to very good schools, they live in a cocoon. They live in a cocoon of, fancy gadgets, fancy clothes, fancy travel. But they must understand what the real country is like. That's the way they'll become good citizens for the future.
I agree, but just have a look at Section 6.
And then they will become leaders of the nation. They will become...
No doubt. I am not wanting to shirk away. I am only saying that if you are there, you fill it up. After it is filled, you come to me.
Well, let the act be implemented.
But all matters are pending here.
For instance, I have seen, for instance, in Sanskriti school.
Yes.
Sanskriti, you have children coming in from the...
I know, I am aware of Sanskrit.
Yeah, nearby slums, nearby, children of household helps. Yes, there is a problem. I also see, because, when these children interact with children coming from extremely affluent families, they have to have also an adjustment process. So that's what life in India is all about. How can we say that we will only interact with, children belonging to, like economic strata? They must learn to interact with...
There is one more problem. There were interim orders operating without pending.
I'll tell you, speaking for myself, my greatest learning experience was when I moved from a very good school, which my parents had put me into in Mumbai. I was the first generation of family who went to an English school. My parents studied in a Marathi school. They naturally felt that we should be put into a good English school in Mumbai. So they did that. But coming to Delhi, I came to a school in Delhi which was far more broad-based, had a much more holistic understanding of life in Indian society, because you had friends, you had colleagues from different strata, you understood, what travels different people go through.
I quite appreciate.
So if you recall, when we went to Delhi University, we had students from the Northeast who were studying with us, right? When those students from the Northeast came and studied with us in the university, we understood what the problems of the Northeast were. Until then, who knew about the Northeast? Because, those students were never with us in school. You were young children.
A lot of our
children extremely innocent of the world around you.
A lot of our judges belong to the Supreme Court from Northeast.
Of course, Justice Gogoi came to
Delhi University.
Justice Gogoi was a student of Delhi.
So many of them.
So many of our batchmates in campus law.
Not only two things I want to say. If your Lordship sees Section 6, the duties of the state to provide and establish these schools which are covered here. The duty is not on me. I am roped in because the state was unable. That's how it happened.
But, that the state providing education for, the marginalized is not just a product of quantity or volume, but also of quality. However good state schools are, they can never compete with the kind of resources which good private schools.
There is one more problem. During the pendency,
look at this.
During the pendency of these matters, there is an interim order. Sessions started, in April or May. Today we are in August. Now there is a mandamus that you fill up with those, some people we took, because the provision was stayed against us. The provision was stayed against us. So, we had to take. Now, after it is over, the session is over, how do I meet, that backlog? It's all full. Operative direction now.
Page 69,
operative direction now says, you fill up the balance.
I tell you what, the obligation is not just of the state, it's the obligation of all of us who have received the benefits of being brought up in this great country to ensure that people who are less fortunate get the benefit of moving ahead on the social ladder. As much, it's not just of the marginalized that they must mobilize, it's the benefit.
I can only say, all those matters are pending.
Speaking of you personally, how much social work you do yourself? In terms of,
I quite understand that.
We have to everybody has to make a sacrifice if, if these children really have to have a real opportunity to succeed. I strongly believe in that.
I quite appreciate the sentiment of the court. May only say, all the matters are pending here. Why should Maharashtra not be pending?
Maharashtra is right. We don't have to entertain.
Hyderabad is here. Karnataka is here. Himachal is here.
Yes.
Lordship, this is the special leave petition filed by the female doctor, sonologist and owner of the...
You engage a doctor who is unqualified. You are the owner of the...
No, Lordship.
And that woman who's treated in your hospital.
Actually, Lordship.
She loses the uterus. She suffers a uterine injury.
Lordship, that case was done by the doctor was appointed. Who had done that case? Actually, that substituted Lordship.
You are responsible. You run the hospital. You run the clinic.
Lordship.
You can't say that my doctor substituted somebody who doesn't have.
That's the unfortunate part of
that woman patient who comes and says, "Well, what have you done?"
No, Lordship. That's the unfortunate part, Lordship. We also feel.
It's absolutely correct. Thank you.
Lordship, just give me a second, Lordship. Just give me a second,
We have
Lordship.
to have a victim-oriented approach in these matters. I mean, there's.
Lordship, just give me a second, Lordship. Just give me a second, Lordship. Today is the 15th day of my punishment, Lordship. 15th day. Lordship, in my whole entire career of 20 years, Lordship, I've never taken off.
They have suspended you for 30 days, right?
Lordship, today is the 15th day, Lordship. I am suffering punishment, Lordship, and the writ petition has been admitted, Lordship.
30 days you've gotten away with very lenient punishment.
Lordship, please appreciate, Lordship. I have not taken a single off. I have not taken a single off, Lordship.
The face of that woman who was treated for a uterine ailment and who suffered at the hands of the clinic. That's the tragedy, that.
Lordship, in my case, what happening, Lordship? My writ petition will be, Lordship, infructuous. Deemed will be rendered infructuous, Lordship.
44.
Lordship, please, Lordship, just give me a second, Lordship. I will convince Lordship. I will convince Lordship.
No, thank you. Yes, Mr. Hegde.
Let me just explain the problem to you. The problem
now ask for the NEET PG reschedule.
It has been done.
So many problems in the country.
Yes.
And now to reschedule a postgraduate NEET examination.
It has been rescheduled earlier this year. With barely 10.
Some point
Just let me explain the problem.
They're all children, really, for all of us. Let them have
Let me just explain the problem, my lord, and then I'm in your hands. Let me explain the problem. My lords, because of what happened in NEET UG, the NEET PG has been affected. What the administration has done is, it has cut down the number of centers from 1,200 to 500. The difference between the NEET UG and the NEET PG is this. It is the NEET PG three sentences. Let me just.
As brother was saying, nowadays people just come, all right, postpone this exam.
No, we're not asking for a postponement. Please take away prayer A. Prayer B.
Stay the NEET exam.
Prayer B. Prayer B is a consequence of what has happened. Just give me.
Rescheduling.
No, prayer B says one examination. One examination because you are going to have two examinations because you cut down the number of centers. You are going to have an examination in the morning. You're going to have an examination in the afternoon. These two examinations will then be normalized. Now, the normalization is going to lead to another thing. Let me just tell you the problem.
It's not a perfect world. We are not academic experts. Three of us sit down and devise a new educational policy.
You are not
something much better than what the existing policy is.
But let me just point out. I know the time schedule problem, my lords. Just give me 2 minutes.
Mr. Hegde, how many students are going to appear?
About 2 lakhs.
How many are before us?
My lords, about 50 of them. There are 4, but I've got about 50,000
petitioners before us.
Yes, my lords, I've got about 50,000 phone calls. Just give me 2 minutes. Just let me explain the problem.
5 petitioners.
Yes.
To reschedule the entire 2 lakh.
But my lords, there are a whole host of people. Just let me explain what the problem is. Because you have two exams, you're going to have 2 papers, normalizing it. Once you normalization is like the Duckworth-Lewis system. It becomes inherently problematic when each mark counts. 1 mark will make a difference. I don't mind an examination being held day after tomorrow as long as it is 1 exam. The problem is this. My lords, just let me explain the problem. Let me explain the problem.
Matter of principle, will not reschedule or pass any orders on.
I am not asking for a rescheduling. I am asking.
There are 2 lakh students and close to 4 lakh parents who would weep over this weekend if we even touch this matter.
they have gone from place to place. There are equally people who can't make the examination.
At the behest of 5 petitioners, we put the careers of 2 lakh students in jeopardy. Will not do it.
My lords, it's not 5 petitioners alone. There are so many who can't approach your lordship.
Certainty this year. Let there be certainty now for these medical.
My lords, absurdity is not certainty. That's the problem. The problem is this. The problem is, just 1 minute, my lords. 1 mark makes the difference.
I'll tell you one thing.
Please, my lords.
There's also, I'm not saying about your client.
Please.
We don't know who is behind these petitions.
My lords,
because the larger the number of centers, it always serves the purpose of those who want to doctor the system.
Forget all that. Just let me explain what the problem is. In 1 mark, I will determine whether I become a radiologist or I go into forensic medicine. Now, that mark is something which I should earn. It is not something which should be normalized. When you have 2 papers, the normalization happens. Inherently, those marks will not be.
But you're absolutely right.
Now, why do you go into these 2 papers? Why do you go into these 2 papers?
You're right that normalization is not the most ideal remedy. The simple answer is that you all live in an extremely diverse, geographically diverse, physically diverse, culturally diverse nation. So therefore, if you have to have these large examinations,
this is the first time that this is happening. This is the first time this is happening. My lords, sometimes a pause to do the work perfectly is a good thing. I am not responsible.
Right? We have moderation. If 2 sets of question papers are given to the students, one has a difficulty level of say 9.9, while the other has a difficulty of 9.85.
Yes.
Moderation takes place where it takes that's how it.
Not in a competitive exam where 1 mark determines my fate. That's the problem. That is the real problem, my lords. 1 mark determining my fate should be something.
Your argument is postulated on ideal solutions. We are looking at it from the solutions in an extremely complex society where these are the solutions.
I'm not asking your lordships to substitute your feel for what the administrators are doing. But if the administrator then makes a problem out of what was a solution, all together, all these years, we've had just one examination.
Item 12. Item 12.
What do you want to do?
Who's appearing in item 12?
I'm appearing.
Item 12 dismissed on delay of 558.
No, my lords, I'm appearing in item 12.
I beg your pardon, lordship.
I'm appearing in item 12.
I beg your pardon, lordship.
My lords,
Lordship, I beg your pardon. My lordship, I beg your pardon.
Just a moment.
7 people talk at the same time. The best thing for judges is to.
My lords, but in item 12, my lords,